Hi everyone. I've recently done a talk on predatory marriages, and I thought it was a really helpful um, tool and really informative. There's quite a lot out there at the moment. It's quite a newsworthy topic, so I thought sensible to do a talk on it. So, for those who don't already know, the general position um, as to how marriage interacts with wills is that a marriage will revoke a will. I've always found it quite interesting that the will is revoked by marriage but not on divorce, so they're treated quite differently. Section 18, so of the Wills Act, applies both to civil partnerships as well as marriages. And as in Re Roberts, the 1978 case that I've mentioned, even if the marriage is annulled at a later date because it was unlawful, it still revokes the will. So the will cannot be reinstated, even if the marriage was deemed unlawful. So that's quite important when we look at predatory marriages, which we're going to look at. So predatory marriage, it's not a legal definition, but STEP have come to some sort of definition here, whereby it's deemed that a marriage where one party is vulnerable and has been induced to enter into it by the other party, who will make money from it. So I think the financial gain element is quite important, and the vulnerable victim who's been exploited either by marrying, and also there are situations where the victim has been induced into changing their wills. I think there's a recent BBC documentary which outlines this. So I will go into cases later on, but there are some situations where the victim's family are not aware of the marriage until after the victim's died. So should we be concerned? I think so, not to scaremonger, but equally to be cautiously aware. As I've set out in the slide, there are 850,000 people in the UK who had dementia in 2021. No doubt it has and will continue to increase as we have an aging population. And so there's quite a lot of scope for people to fall victim to these types of marriages. And as I've set out, STEP, you've already said there's been a steady 13% increase in these types of cases, which I think is a significant number. And the fact that the Law Commission are also concerned or aware of concerns around predatory marriages is quite important to note. There's also a potential reform or relaxation of rules surrounding where people can get married. So, which is great, I think, to a degree. But if people can get married at home, for example, then we need to make sure there's safeguarding in place for vulnerable victims, because it would then be much easier for people to get married. And we need to have careful consideration about what safeguarding measures are implemented to protect those who can't protect themselves. So in terms of capacity, obviously capacity to make a capacity to get married are very different. The capacity to make a will, as I've set out here, Max Goodfellow, and the what was discussed in the recent case of Baker and Houston, the interaction between the Banks and Goodfellow test and the Mental Capacity Act. But it's well trodden known and it's quite a high bar for the capacity to make a will. In comparison, the capacity to consent to get married is quite low, as I set out in this case, Sheffield, and another 2004 case. The judge said that the contract of marriage was a simple one which did not require a high degree of intelligence to understand. The test for capacity was considered in this water protection case and DMM case in 2017. It's quite an interesting case. EJ is the daughter of DMM. She brought the case to try and stop the marriage between DMM and his long-term partner, SD. DMM suffered from Alzheimer's disease. One of the biggest issues was that if they were to marry, the will, DMM's will would be revoked, which was primarily in favour of his three daughters. If he married and the will was revoked, the estate would be dealt with under divorce of intestacy, which would then pass the majority of the estate to his would-be wife. So the case raised the question as to whether the legal capacity to consent to marry required in addition to the test set out under the Mental Capacity Act, the person to understand that the marriage would automatically revoke the will. The court held that it did require a level of understanding, but it also gave the parties permission to appeal to the Court of Appeal. What, however, was found in this case, Dr. Series was a jointly appointed expert, and he found that actually DMM did understand the impact of the marriage would have on his will, and the fact that his children may receive less and his would-be wife would receive more. So, based on the confirmation of the capacity test to include the additional element, he was found to have capacity to consent to marry. So it didn't actually go to the Court of Appeal, didn't it? So that's the capacity. So this is very different levels, but interesting that the lower level marriage would revoke higher level will. So Joan Glass had mentioned very briefly, it was a story that was in the news, I think 2021. It was in the news. Her daughter has still tried to keep it in the news. She campaigns for reform and changing laws following her mother's case to try to prevent predatory marriage. I set out the overview on the slides, but Joan was a 91-year-old widower with severe vascular dementia. She also had terminal cancer. She met a gentleman by the name of Coleman, who was in his late 60s. In the same year, she got diagnosed. He obviously was much younger than her. He began, as it tends to, unfortunately, helping her with shopping and DIY. This situation is slightly different because Joan lived at the end of her daughter's garden, so the family could see the comings and goings. Coleman actually moved in with her, Joan, a month after meeting. The family say that initially was friendly, but he moved towards becoming quite controlling of her. He actually started a hate campaign against Joan's daughter. As a result of this, the family obviously became concerned, and Joan sought advice from social services, the GP, but was told there was little to be done. Sadly, Joan died in 2016, and the family learned after that she and Coleman had got married in secret in 2015. No one knew, the family weren't aware until Coleman produced a marriage certificate, which obviously revoked her 2004 will, which left everything to her son and her daughter, and left her estate to be dealt with by Coleman and distributed under his intestacy. Obviously, the family took issue with the fact that Joan, who at times couldn't remember her own name or her age, had been allowed to get married. They said that she didn't know who Coleman was. They were often confused as to why he was in her house. The family thought that the registry had been fooled by Coleman into believing that Joan was not, obviously, didn't lack capacity, but that she was forgetful as a result of a stroke. So, on raising these issues with the registry, the family and the registry was quite dismissive and evasive. If we look at the Capacity Act, if Joan was unable to remember her name and her age, was she truly able to understand written news and weigh up information as to the reasonably foreseeable consequences of the marriage, including that the marriage would automatically revoke the will? I'll suggesting that if she can remember her name. Her daughter did have power of attorney for her, but didn't give her any more security or assistance as a young Joan who did it. So Coleman obviously took control of funeral directions. He had the right to obtain letters of administration and he rules of intestacy. The family took him to court to try and get control back and the estate. The judge ultimately sided with Coleman. He ended up burying Joan when actually she wanted to be cremated, or had suggested that were her wishes during her lifetime, in a village with which she had no connection and a unmarked grave. So I think what's important is that there are obviously financial implications, but I think there are wider ranging consequences of predatory marriages, which are just desperately sad. The family couldn't go back into the property to get sentimental items from Joan's late husband. Coleman remains in the property, which was next to the family, and they've had to move because they couldn't obviously stay living next to someone who bought such widespread awful. So anyway, Joan's daughter, as I said, is still campaigning, and the key goal of her campaign is so that a will no longer automatically revoke will. Sorry, a marriage will no longer automatically revoke a will. So effectively, it's removing the financial incentive for the predatory marriage. It's effectively what the judges in these cases have been scared to do, and what the executive is trying to do now, and what we hope. So what's the warning signs? As I set out in Joan Blass's case, similar to grooming. So the predator will be charming to gain the victim's family's trust. They will use coercion, control, gaslighting. Victim is usually vulnerable, and that would mean obviously compliant. As in Joan Blass's case, the perpetrator will try to control the narrative. So Coleman controlled the narrative with the registrar, and we can do that with doctors, sexual services, etc. The ultimate goal will be to marry the victim and invalidate the previous will, or as with the Sixth Commandment, the BBC documentary series, to induce the victim to change their will. So warning signs have been helpful. Difficult though, I think, especially in Joan Blass's case, the family lived next door to each other. So we have a look at what preventative measures can be taken. This is an interesting case from the Court of Protection. It's a good example of the court's power in preventative measures. So a 70-year-old woman, BU, who had been in a relationship with MC for 5 years. MC was, in this case, much younger, and the family had become increasingly concerned about the relationship dynamics between the two, and that MC was becoming more controlling over in her day-to-day life. The court appointed a financial deputy, and the family took the matter forward and wanted to protect BU. She had an estimated value of her estate was about 1.3 million. So if they'd have married, there would have been significant change to the distribution of her estate. What's interesting, I think, about this case is that MC had a history of convictions for black men and dishonesty. So it shows what type of character he was. He also was arrested in 2020 when he attempted to liquidate one of the funds that was owned by BU. The official solicitor, interestingly, said that MC was a trickster whose long-term lifestyle appeared to repeatedly involve taking money from vulnerable people through coercive control and blackmail. The judge actually held in this case that the BU lacked capacity to decide on contact with MC, and made an order for no contact and an interim 12-month forced marriage protection order. So preventative measures do exist. They are expensive to implement. And with regard to the protection it raised, they need to lack capacity to make decisions about contact or marriage. So it's sensible to know but they might not be applicable in every case. So what can we do as practitioners, as family members? Remain vigilant, keep nice communication open, don't allow perpetrators to push you away from it will be difficult. Raise concerns with the relevant safeguarding professionals. The best option will be to try to prevent the marriage happening. Stay alert to the possibility that predatory marriage is an option, and even if they don't have sufficient capacity, as in Joan Blass's case, it still happens, sadly. So to try to prevent the marriage happening, I wasn't aware until I did the research for this, but you can enter a caveat to prevent the marriage. Obviously, a different caveat to the one you'd lodge at the probate registry, but similar implications in that they stop the marriage. It is not fail-safe, as it only applies to marriages and registries, and if it's a religious venue, then you need to look at the bans that are read and keep an eye on that. Obviously, seek advice on all these points from the appropriate solicitors. As in the case of BU, you can seek an injunction against the perpetrator or forced marriage order. So that's preventative measures to try and stop the marriage happening. If unfortunately the marriage has already taken place, you can try to get the marriage annulled. And if the victim has got capacity, get a new will drawn up, because obviously even if the marriage is annulled, the will still is invalid. If the victim lacks capacity, you have to apply for statutory law. Sadly, if, as in Joe Glass's case, the victim has died, you could seek advice as to any potential claim under the 1975 Act. There is a new case, recent case, of Dr. Kaladiki, which I think is interesting, because her sister, who was due to inherit under a will, which was revoked by marriage, is bringing a claim on the basis that the will should have, or was intended to have, taken effect irrespective of the will, even though it wasn't expressly within the will. So Dr. Kaladiki died on the 31st of December 2018. She had a significant estate of 9-10 million. She signed a will. She was terminally ill. She was in hospice at this point. She signed a will on the 27th of December 2018, which left her estate to be divided between her colleague, Dr. Latimer, and her family. She then married Dr. Latimer. I think it was a matter of hours after signing the will, 28th of December 2018, which, as I explained, revoked the will, making him the sole beneficiary of her estate. So Dr. Kaliki's sister claimed to rectify the will, as she claims that the will was made in expectation of marriage, and it was a clerical error, and that her sister would not have intended it to have been revoked by the marriage. So this trial is due to take place at a later date, but at this hearing, Master Clark said that Dr. Kaladiki's sister had real prospect of showing that the will was ambiguous, and that her sister had intended it to survive her forthcoming marriage. She said that they would be able to put forward the argument at trial that there was a clerical error or a misunderstanding of Dr. Kaladiki's intention. So it'd be really interesting to see the outcome of this, because then that would be a way of rectifying the will so that it doesn't invalidate it by marriage. On a more holistic view, generally, there are campaigns still going on. Obviously, Joan Glass's daughter is still campaigning for the law on wills to be changed, so marriage does not automatically revoke a will, and also create an offence of predatory marriage. So remove the financial incentive and deter with a criminal offence, which isn't currently in position. Scotland, interestingly, the law is such that marriage does not automatically revoke an existing will, so we would just be going around about. I think there are changes and we need to look into it, but it doesn't automatically revoke the will like this country. The Law Commission is considering the issue, and I understand the Section 18 of the Wills Act is due to be reviewed in September 2023. So at the end of this year, we hopefully have an indication as to what, if any, amendments are planned. And also, importantly, I think more safeguards at the point of marriage. So registrars at the moment, it's not mandatory for them to interview a couple separately. It's best practice. So at the point of marriage, it's sensible to have more safeguards, and also the ability for the registrars to refer a couple or an individual for capacity assessments if they have such concerns. So more training. Slightly away from predatory marriage, but in terms of marital status and how this can impact wills and succession planning, I think it's important to always understand your client, if you're will writing client's position, so you can give them the right advice, because we have situations where a couple is going through a divorce or a separation, actually they haven't updated their will or the ownership of the property, and one of the parties dies during this period, this very kind of limbo period, and it can be really quite problematic. So it just points to bear in mind, if they're married or engaged to be married, make sure the will is up to date after they've married, or if they're doing it before, that the correct wording is included, so in contemplation of marriage. If the client is divorced, make sure the client has a consent order which disposes of 1975 Act claims. And if they are, like I said, in the period of divorcing or separating, make sure their wills are up to date and reflective of what they want. So consider an interim will to cover that period, which can then be reviewed if necessary, once matters have been finalised. As you'll hear, you're probably already a member of the IDRM, but anyone who isn't, as a reminder, we currently run contentious clinic webinars, which are proving to be quite popular. So we have fact sheets, case comments, triaging, information about us as a firm, and you can sign up for notifications of up and coming webinars if you want via the IDRM. So hopefully that was helpful. Any questions, let me know. And I can pop back on and provide an update if any of the reforms come to. But thank you very much.